Welcome everyone. I'm Dr. Julian from the Amsterdam Center for European Law and Governance, for those who don't know me. And yeah, I'm happy to chair the first SepaRope lecture of this new academic year with Julian Scholtes, who joins us today from Glasgow. SepaRope is our project with the Eric Kasten Institute of International Law and Human Rights, the Center for European Research at the University of Gothenburg, and the Amsterdam Center of European Law and Governance. And that's why we also still have this format that we meet at site here in Amsterdam and also online. So our speaker today, Julian, he's a lecturer for EU law and public law at the University of Glasgow, and before he worked at the Newcastle University and did his PhD at the European University Institute. And he works on the abuse of national constitutional identity, and especially of this argument of national constitutional identity in the EU. And today he's presenting to us his research on this issue. So I will, without much further ado, give now the floor to Julian, who will talk to us for about 30 to 45 minutes. And afterwards we will have a Q&A. So Julian, the floor is yours. Thank you.
Okay, thank you. I'm just gonna set a timer for myself. All right. Thank you so much for the invitation. It's great to be able to talk about my research. So I'm gonna share my screen because I have some slides prepared. I hope that showed up. So I'm going to talk about the idea of abuse of constitutional identity as sort of a theoretical frame through which we can distinguish, let's say, less problematic, more ordinary invocations of national constitutional identity against the primacy of EU law from such that are illegitimate, nefarious, abusive in some way. To start off, to give some background, of course, this concept of constitutional identity over the past 15 years or so has become a very central figure in the contestation of authority between national constitutional courts and sometimes national governments on the one side, and the European Court of Justice and the EU more generally on the other. And we all know that the relationship between EU law and national constitutional law is notoriously ambiguous, as both the Court of Justice in Luxembourg and many national constitutional courts will claim for themselves the ultimate authority on conflicts between certain crucial elements of the national constitution and EU law. And these theoretical conflicts between EU and national law threaten to turn into actual conflicts of authority, where the conflict pertains to certain core competences, values, or other constitutional features at the national level, which courts often refer to as national constitutional identity. And following especially the jurisprudence of the German Constitutional Court, many national jurisdictions have followed suit in developing similar doctrines of national constitutional identity that set limits to the primacy of EU law. We see similar things and we see similar doctrines being developed, for instance, in Belgium. We have similar case law in France. Of course, we have the long-standing line of jurisprudence from the Italian Constitutional Court, which does not directly use constitutional identity language, or has only recently started doing so, but very much exists in a similar vein. And these conflicts between EU law and national constitutional identity, where they do arise, can often be quite constructive, right? In the most positive instances, national constitutional courts can leverage constitutional identity as a way to induce the Court of Justice to consider a course of action that will actually be more in line with the EU's own foundational values. And these challenges can end up strengthening the legitimacy of the European project as a whole, and place it on more robust foundations in the long run. And we've seen some conflicts play out in very productive ways. Think of the Tarico saga between the Italian Constitutional Court and the European Court of Justice, or the disputes surrounding the European arrest warrant with the German Constitutional Court. However, these benign invocations of constitutional identity have recently been overshadowed by more questionable constitutional identity claims, which cast a more dubious light on the idea and the value of constitutional identity as a whole. Most prominently, perhaps, both Poland and Hungary have seized upon existing national constitutional jurisprudence on constitutional identity, and above all, and especially, the case law of the German Constitutional Court, in the pursuit of nationalist and authoritarian constitutional projects that place it squarely at odds with the values of the EU and European integration as a whole. Right, as we all know, both the Polish and the Hungarian governments have, over the past 7 to 10 years, put their respective countries on the path to essentially autocracy, eroding checks and balances, bringing many state institutions, including the judiciary, under control, under government control. And in the Hungarian context, the Hungarian government, for instance, relied on the constitutional identity argument as a reason to resist joint European action in the refugee crisis. This was the famous judgment from 2016 that was then instrumentalized by the government as an argument to say we cannot participate in the refugee relocation program that was agreed in the council. And they argued this with reference to the purported importance of social and ethnic homogeneity to Hungarian constitutional identity. Essentially, the argument was that the Hungarian constitution, the Hungarian conception of the people, prevents Hungary from resettling any foreign population on Hungarian territory. And there's a sort of a rift between, on the one hand, more multicultural constitutional identities that you find in Western Europe and more mono-ethnic, monocultural identities that you find in Central and Eastern Europe, or so the argument ran. In the Polish context, we've also seen constitutional identity being instrumentalized in similar ways, right? Constitutional identity was invoked by both the Polish government and the unlawfully composed Constitutional Tribunal as an excuse to, or as a defense for its judicial reforms that have come under wide criticism for effectively eroding the rule of law and eroding judicial independence, despite and most recently against repeated judgments of the Court of Justice that find them incompatible with EU law. And these more questionable invocations of constitutional identity might lead one to dismiss the concept as a whole, right, as inherently dangerous. The critics of the concept argue that the language of constitutional identity can be too easily used to further nationalist or nativist causes and to undermine the supremacy of EU law. And they also charge that the concept is just too indeterminate. We just don't know what exactly it means, so that it can just be filled with random meaning by anyone. And so rather than indulge the language of constitutional identity, they argue we should simply endorse the unconditional supremacy of EU law and just get rid of constitutional identity as a concept altogether. Now, I find this approach unsatisfying for several reasons. Firstly, dismissing the idea of constitutional identity just straight out of hand might run the risk of understating the complexities of the European constitutional order, the ways in which European and national authority are stacked upon one another, and the ways in which identity, rather than just being able to be bracketed or displaced in certain ways, is just something that has to be reckoned with in a lot of ways. It might also sell short any potential value of constitutional identity arguments that are actually made in good faith, seeing as the Court of Justice and the EU in general cannot completely sidestep considerations coming from national constitutional orders. So rather than banish constitutional identity from our conceptual vocabulary, I think we should more clearly think about how can constitutional identity be abused, which is what the main part of my research, my PhD research, and also this presentation is going to be about. In order to get a clearer picture of what abuse means in this context, we need to think concretely about what are the normative expectations that an argument from constitutional identity elicits, right? What are courts actually claiming or invoking when they make a constitutional identity argument? And once we have a clearer idea of this, the concept of abuse becomes a lot clearer. Abusive constitutional identity arguments essentially betray or even undermine the normative connotations from which they try to benefit in the first place, right? And so my thesis, forgot that slide. My thesis conceptualizes the abuse of constitutional identity in three dimensions. I try to think through this in three dimensions that interact and overlap with each other in different ways, and I'll go through each of them. The first dimension is the generative dimension, right? And in the generative dimension, we think about how has a constitutional identity claim actually come about? How does constitutional identity stand in relation to things like constituent power, the concept of the people, broader ideas of democracy in relation to the Constitution? In the substantive dimension, we ask, what does the claim actually entail? How does it stand in relation to maybe a broader normative concept of constitutionalism that it tries to benefit from? How does it stand in relation to the values that frame the joint exercise of authority in the EU, in the European legal area? And then in the third, the relational dimension, we ask about how is the claim, how is the argument advanced? What is the intention with the argument? Is the intention to engage in a dialogue, to raise certain to raise certain concerns, to elicit a demand for recognition of diversity, or is it to just completely disengage from competing authority, right? So these are the three dimensions in which I try to think through the idea of constitutional identity. And abusive constitutional identity arguments, I try to point out, operate from a conceptual plane that has been completely warped and deformed by the authoritarianism that they try to bolster in a lot of ways. They misconstrue and distort the meaning of constitutional identity as well as its relation to all of these core concepts in a lot of ways. All right, just a second. Let's start with the generative dimension, right? How has a constitutional identity claim come about? In the generative dimension, as I already said, constitutional identity relates to ideas like constituent power, democracy, some notion of the people. Claims that something is part of a community's constitutional identity invokes the people standing behind the Constitution, right? A form of collective selfhood. And as such, it clearly ties into a democratic constitutional imaginary. And so this necessarily raises the question of how a constitutional identity claim can plausibly attest that it authentically speaks in the name of the constitutional people, rather than merely expressing a spontaneous political whim or an arbitrarily constitutionalized worldview, right? And in this context, we often see constitutional identity being tied to some kind of doctrine of unamendability, right? We see this most prominently with the eternity clause in the German Grundgesetz that the Bundesverfassungsgericht, the German Constitutional Court, keeps going on about. This sets the absolute limits to our ability to participate in European integration. And behind this idea ultimately stands the very, very Schmittian conception of constitutional identity essentially consisting of the decision that the constituent power has made for a specific type of political existence, for certain principles guiding political life, and so on. And what I try to work through in my thesis as well is that I think this line of argument needs to be put in its proper place. It needs to be toned down in a lot of ways, because it does not really match the considerations that go into contesting authority between national constitutions and the European Union in a lot of ways. First of all, in a more general theoretical sense, I think that ultimately the arbitrariness of acts of constituent power, right? We have no way of attesting legitimacy to constituent power while constitutions are being made. We can only really attest legitimacy to constitutions retroactively once a constitutional community accepts a constitution as its own by living through it. And so this also means that constitutional identity is not statically fixed at the moment of constitution making. It dynamically emerges as a polity lives through a constitution over time, and so it's also capable of change within the constituted order. So we need to think about the relationship between constitutional identity and eternity clauses, I think, in a much more complex way than some of the courts that are engaging in this argument are trying to suggest to us. And we'll get back to that as well in the relational dimension later. Now, if this is the case, if constitutional identity is capable of dynamically changing over time, then there have to be some kinds of generative requirements to the legitimacy of constitutional identity, because now constitutional identity is emerging within a space where the requirements of constitutionalism already have a bearing, right? And so what I try to argue, and what follows from the separation of powers, from I think the core principles of democratic constitutionalism, is that no one single force inside a polity should be able to decide on a polity's constitutional identity on its own. The mechanisms of a democratic constitution are there to guarantee that whatever is being advanced as constitutional identity or otherwise can also be credibly considered as such. And with that in mind, I discussed various facets of constitution making and constitutional change with a view to the generative abuse of constitutional identity, right? So I discussed things like spontaneous constitutional amendments, things like court packing with a view to arriving at more beneficial judgments. Other things I'll go into more detail on that. On an interpretive level, sort of severing constitutional identity from constitutional text, which is something we've seen in the Hungarian context happen quite a bit. And then also with a more specific focus to the Hungarian example, also the regulation of historical memory. I'll talk about that a little bit later. On that point, I actually owe a lot to a former researcher from Amsterdam, Marina Ban, whom I've had a discussion about this with. All right, so let's talk about the spontaneous or abusive constitutional amendment as a means of arriving at some kind of constitutional identity claim. What happened in Hungary, for instance, is that I think in 2013, just after the new constitution was adopted by Fidesz under already questionable circumstances, the government passed the Fourth Amendment to the Hungarian constitution. And this Fourth Amendment to the Hungarian fundamental law explicitly banned the substantive review of constitutional amendments by the Hungarian Constitutional Court, while at the same time also constitutionalizing several policies that were previously declared unconstitutional by that court. For instance, the decriminalization of homelessness. And so through this move, constitutional amendments effectively became a way of circumventing ordinary functions of judicial constitutionality control. And this instrumental attitude, this instrumentalist attitude to constitutional amendments that we could see from starting with the Fourth Amendment was something that very quickly percolated into the area of constitutional identity. We saw it first with respect to migration, when in 2018, the Seventh Amendment to the fundamental law, the Hungarian Constitution, simultaneously constitutionalized a ban on the settlement of foreign populations in Hungary and made the protection of constitutional identity a duty of all organs of state. We also saw it 2 years later in 2020, I think, when the Ninth Amendment to the Hungarian fundamental law was passed, which enshrined essentially conservative views on family and gender in the constitution, while proclaiming the right of children to be educated in accordance with our constitutional identity. And these instrumental amendments to constitutional identity essentially reveal a performative contradiction, in my opinion, that makes them abusive, right? If you spontaneously add new clauses to the Constitution in order to claim them as your constitutional identity, you can hardly make the case that you're actually speaking on behalf of authentic and deep commitments of the constitutional community. And in other words, the more you debase the value of constitutionality by treating your constitution as a policy book, the less credible any invocation of constitutional identity really becomes. And then, as I already mentioned, I also discuss other developments as potential generative abuses of constitutional identity. For instance, packing constitutional courts with faithful judges, as I said, as we could also see in the Polish case, for instance. Other developments take place at a more interpretative level. For instance, severing constitutional identity from constitutional text, as the Hungarian Constitutional Court, for instance, does when it argues that the Hungarian fundamental law, the Hungarian constitution, is actually something that is logically posterior after any idea of Hungarian constitutional identity. Constitutional identity in the view of the Hungarian Constitutional Court is seen to pre-exist the actual Hungarian fundamental law, because they say it is grounded in Hungary's historical constitution. Right, so they anchor Hungarian constitutional identity essentially in constitutional history, in sort of the holy crown of Hungary you see in the picture, and all kinds of historical documents that were part of Hungarian constitutional practice before there was a rupture with the end of the Habsburg Empire and then eventually state socialism. The problem with that is that this historical constitution can hardly be actually reconciled with any form of a documentary constitution as we're now seeing in Hungary. So the question becomes, is this historical constitution actually a credible form of legal practice, or is it just a smokescreen to introduce other considerations? And I think that's something where the regulation of historical memory at the same time also comes in, right? We see very, very heavily within the Hungarian constitution certain historical narratives being constitutionalized. And so you have almost a mutual interaction happening there. On the one hand, you're historicizing the constitution in a lot of ways, but on the other hand, you're constitutionalizing a certain narration of history. And so the space within which what you might claim is constitutional identity can actually emerge becomes more and more constricted through that interaction. All right, let's move on to substantive abuse, right? So secondly, we have the substantive dimension. And in that dimension, we effectively ask, what does a constitutional identity claim entail? I actually found it quite hard to develop any kind of litmus test for I think it's impossible for when is a constitutional identity substantively abusive. But I think inherent in arguments from constitutional identity is necessarily a more general normative sense of what a constitution is and what a constitution ought to achieve. And the argument from constitutional identity is necessarily constrained by an idea of a normative idea of the Constitution. Without these constraints, without being constrained by some kind of normative idea of constitutionalism, constitutional identity would ultimately collapse into a mere statement of fact, almost an analytical statement in a lot of ways. But I think we have to understand constitutional identity as a concept that is tied up in a bundle of expectations about what a constitution is and what it ought to achieve. And for these expectations, I differentiate between, on the one hand, conceptual expectations and contextual expectations. Conceptual expectations are firmly tied up in a distinct normative view of democratic constitutionalism. And in my work, this directly ties into the work that I did in the generative dimension, right? If we understand things like the rule of law, things like the separation of powers as integral to the generative legitimacy of certain constitutional identity arguments, then that also has ramifications as to the substance of what you can claim as constitutional identity. If a non-independent constitutional court cannot plausibly be said to speak to constitutional identity, then eliminating judicial independence substantively also cannot be a legitimate thing to claim as a matter of constitutional identity. Contextual expectations, on the other hand, arise from the concrete context of European integration within which constitutional identity arguments are made. The normative expectations that member states pose to one another in the context of European integration, in this sense, also form part of the substantive boundaries to which the concept of constitutional identity can be pushed. Substantively abusive constitutional identity arguments essentially try to sever constitutional identity from these requirements, rather than seeing constitutional identity as a particular national take on a joint normative practice, the practice of constitutionalism. It leverages constitutional identity as a way to transcend those requirements, essentially. I think, wait, there's some parts that I'm going to skip over. Right. So let's talk about the case of the Hungarian case of immigration for a bit. In the Hungarian case, this argument, the constitutional identity argument, has run that the settlement of refugees on Hungarian territory poses a threat to the constitutionally enshrined social model of Hungary, namely a monocultural, mono-ethnic society, as opposed to the more multicultural societies of Western Europe, allegedly. In the name of preserving social homogeneity, the argument ran Hungary should not have to resettle refugees on its territory. And what I argued in my dissertation is that this social homogeneity argument it rests on assumptions that are impossible to reconcile with an open society based on constitutionalism in a lot of ways. In the wider framework of the new Hungarian fundamental law, this homogeneity ultimately becomes a stand-in for political closure, the need not for a shared democratic or political imaginary, but for substantial sameness in how citizens lead their lives. Not enabling or stabilizing pluralism within a society, but eliminating it, right? And as for Poland, we can also similarly sort of go through this substantively in some ways, right? The Polish judicial reforms that are defended as a matter of constitutional identity undermine the independence of the judiciary, and thereby they erode rather than sustain constitutionalism in a lot of ways. Arguments that they're merely establishing a different form of political constitutionalism that are truer to previous iterations of Polish constitutionalism falter in a lot of ways, because rather than limiting political power, these judicial reforms repurpose courts as another means of generating political power. And as such, the defense of these judicial reforms as a matter of constitutional identity should be regarded as a substantive abuse of constitutional identity. Finally, we get to the relational dimension of constitutional identity abuse. And by this, I mean that constitutional identity claims cannot only be abusive by virtue of their substantive content or by virtue of how they have come about, but also by virtue of how they are advanced concretely. In the relational dimension, constitutional identity claims purport to be part and parcel of sort of European constitutional pluralism. They tie into notions of pluralism, diversity, accommodation, and dialogue in a lot of ways. And as such, they should provide reasons to start a discussion about where increased relative authority between national and European courts should lie, rather than provide a reason from the outset to detach from any relation with an overlapping constitutional order like that of the EU. Constitutional identity, I argue, cannot be legitimately invoked to entirely disengage from other constitutional orders, such as that of the EU. And this is where we get back to the generative dimension that I stressed earlier, right? That if constitutional identity is not so much self-evident or given by the constituent power and eternally enshrined, but rather something that is plastic and dynamic and capable of change, our awareness of that has to moderate the confidence with which we advance constitutional identity claims in order for them to be legitimate. And this is where actually I think we can and we should criticize the German Constitutional Court very strongly for its excessive reliance on the eternity clause, because I think it has failed this task in the past. It has, especially in cases like the OMT case, but also in the PSPP case recently, it leans upon a highly charged and excessively detailed and substantive interpretation of the German Constitution's eternity clause in order to try to force the hand of the European Court of Justice in a lot of ways. And in this sense, the German invocations of constitutional identity can be criticized because they excessively lean on the eternity clause in a lot of ways. And it also has negative ramifications for the German constitutional order as such, right? The more you try to flesh out constitutional identity externally as a way of forcing the hand of another constitutional actor, the more you also restrict the ability of the constitutional community internally to reform, reconsider, and dynamically develop its constitutional identity in a lot of ways. And this then goes at the expense of the democratic legitimacy of constitutional identity claims. But I think ultimately we also have to consider sort of the radical differences that we see here compared to what happened in Poland and Hungary in this respect. In the Hungarian case, for instance, these constitutional identity claims were never advanced to the European Court of Justice in any way. Instead, they were part of an internal conversation between different actors, the Constitutional Court, the government, and so on, about how to leverage constitutional authority in service of politically resisting the implementation of joint European decisions, right? The institutional dynamic that we saw in Hungary in the context of the decision that the court made in 2016 was one of internal monologue, not one of judicial dialogue. It was not one that supported intersystemic engagement in the spirit of constitutional pluralism. in any ways. And in the Polish case, we very much saw the same thing, right? We had the K321 judgment, which of course has to be singled out here, where the court in its press release, which still is the only official sort of documentation we have of some kind of reasoning behind this judgment, the court essentially says, all right, this is a matter of Polish constitutional identity, and because of that, the court has nothing to say about this, the European Court. It's an attitude of complete detachment on the basis of constitutional identity. Yeah, I think there has to be some kind of differentiation about the different ways in which the relational dimension of constitutional identity comes to bear here, because I think that is actually also one of the more crucial parts of the politics of constitutional identity in the end. All right, I'm going to sum up. I think, yeah, it'll take us back to the little matrix that I started and put up in the beginning. So especially when abusive constitutional identity arguments are a function of authoritarianism, these three dimensions of constitutional identity abuse have to be looked at in conjunction. They overlap with each other, they interact with each other. Each of them serves the political closure and the conclusive definition of the constitutional community in a different way, and often they're intertwined, right? So, and especially the generative and the relational dimension interact with each other in a lot of ways. The internal closure of the democratic sphere, the public sphere, to political dissent, to diverging opinions, challenges to governmental authority, is often enabled through the generative abuse of constitutional identity, right? It goes hand in hand. And this goes hand in hand with the external closure of the polity to extraneous influences expressed through relational abuse in this sense. So these two endeavors, the generative abuse, internal constitutional change, and the external closure of the polity from extraneous influences, they reinforce each other. They strengthen each other in a lot of ways. The idea that a polity should not have to give up on its identity externally feeds into the idea that its identity is also fixed and set in stone internally, and thereby it becomes a justification for authoritarianism. Conversely, whoever claims to have conclusively settled the constitutional identity of a polity internally also does not need to engage with any external overlapping authorities. And so in this sense, the idea of constitutional identity abuse should not so much be seen as narrowly engaging with the relation between national constitutional orders and the EU legal order, or as merely trying to find a way to delimit the scope of legitimate constitutional identity arguments. But when you take all the dimensions together, I think it becomes at least a very partial account of a small aspect of how authoritarianism is conditioned under and engages with circumstances of constitutional pluralism that we find in the EU today, that we have to reckon with somehow. All right, I think that's all I've got, and I'm looking forward to the discussion. Yeah.